Hi, I'm Carl Bayer. I'm a mediator and an arbitrator and a court master headquartered in Austin, Texas and Livingston, Montana. I'll introduce my co-presenters, Sherry Worth and Tracy McCormick, in just a little bit. Well, so now you're a lawyer. You went to law school, you got your degree, your parents gave you a briefcase, you started to work for a law firm and passed the bar, and you got to know your way around the courthouse. You learned the judges, got to know them, and knew the court personnel and where the clerk's offices were. And all of a sudden, you're quarantined. And you think, well, um, my practice will be on hold for a month or two. Well, uh-oh. Uh, Today we're going to talk about a little bit about online mediation, and then I'm going to introduce you to some real experts that are going to help you with remote advocacy. And finally, I'll close with a few remarks on the state of the profession. But first, I want to turn to some what I would call overarching themes for the day. It's not bad news. It's great news, I think. But first, you're going to have to face the fact that law school just didn't teach you to be a TV producer. Probably feels a little lonely, probably is a little angering, a little disrupting, a little maddening, a little confusing, but there is a way through all of this, and I think the other side's pretty bright. One theme is everything you did before, you can do it now on the online remote advocacy, and you can still do it as well, if not better, for your clients and the decision makers. It's all about the small screen. You got to think TV screen. You're now a TV producer. And so if you'll let that thought run through everything that you're preparing now for your case, I think that shift in thinking will help you with all these points we're going to talk about today. This wasn't the crisis that any of us wanted. It's certainly the crisis the justice system needed. Now, that's a quote from Michigan Supreme Court Chief Justice Bridget McCormick, who's been one of the many leaders on this movement to help courts deal with the pandemic. But I've also got a picture of the Texas Supreme Court building up here, and that's because I want to really, really single out Chief Justice Nathan Hecht, who has truly been the national leader for all courts on developing thoughtful processes to reform the justice system and to respond to this problem and to give us methods we can use going forward in the future. I also want to call out David Slayton, who's Texas's head of Office of Court Administration, and from the very, very start, he had wise, practical solutions to try to help courts deal with all of this. Now, one of the things we have learned is that courts are no longer just a building. They're a whole set of services that we actually deliver to the community, and we can do them in so many different ways now. We're trying to learn several things. One, we've got to really figure out how to deal with all the wonderful anchors and the gravitas of a beautiful courtroom like this, again, on the small TV screen. We've also got to learn that we as lawyers are not some high priest in some arcane ritual that in Latin or Greek, and that we have to take our services to the community too with all these new tools. And finally, what we have learned and are now beginning to try to deal with is all Zoom windows are created equal. Everybody's the same size. This is the great equalizer and the great opportunity, I think. Now, when I first started doing these mediations online exclusively back in March, I was the little weakling on the left side of the screen there. I kind of came to you with hat in hand and said, oh my gosh, I'm so sorry. It's not going to be any good, but it's better than nothing, and we'll get back to normal. And I'm not that way anymore. I have been totally converted. I'll probably never go back on mediations to anything other than online. There's a lot of things that have been improved and very few things that have been lost, in my opinion. Let's talk a little bit about the old way we're doing it. Of course, we all showed up at a big fancy downtown office building that had really expensive parking. And as we're riding up the elevator, maybe you said to me, hey, let's don't do a joint session. But what we had done is we'd essentially created a mediation day. And I literally mean a day. We stacked everything up for that one day. Oh, maybe a little bit before you'd send me a pre-mediation statement, and maybe you'd give me a pre-mediation call. But essentially, we showed up, and then there was this joint session, maybe, or maybe it's a meet and greet. But we'd recess into private caucuses, and I'd spend an hour and a half or 2 hours with each side, and then maybe another short period of time with each side. But basically, you got to spend half the morning surfing the internet and telling jokes and billing your client, and I wasn't even around. So finally, about 2 o'clock, we'd start negotiating, and hopefully we'd get down to some sort of settlement. But the problem was, if we were going to be the least bit creative or business oriented in our solution, it would nearly unravel several times as people would try to draft complex agreements late in the night when everybody's tired and grumpy. So what we've been able to do, I think, with Zoom is basically take this stack of things that we'd all put on mediation day and turn them on their side. There's going to be it's more like a mediation month now, but little short snippets throughout the month. And we essentially have something that corresponds to everything we did before, except I think we're doing it a lot better now. First off, usually about a month out, I'm going to ask you to have a pre-mediation, preferably Zoom phone call with me, just so we can start working out the kinks, just the outside counsel. And we talk about the process we're going to go through before the day we actually get together. I'm going to try to talk you into doing shared pre-mediation statements. I know that's common practice in some states, but it's not in Texas. But what I'll try to talk you into is doing about a 5-page legal analysis and factual analysis that is relatively objective and civil, and y'all will share them with each other and, of course, then your clients. After that, we'll start the confidential Zoom breakout sessions. And I do mean Zoom. I want to be able to visit with you and your clients and at your convenience in a comfortable setting. And usually these are about an hour to an hour and a half long. And we start identifying some things in these sessions that we may need to do later. For example, sometimes it's pretty clear that I, and maybe even the lawyer, and maybe even the client representative, need to know a little bit more about the technology or the business interests involved. And so I've had technology tutorials by an engineer, maybe 30 minutes or so, or a business tutorial by a key business person, maybe 30 minutes. And then we'll also maybe start talking about some homework assignments, and I'll say a little bit more about that later. Usually we get back and we have a second confidential breakout session. And here's where we really get down to planning what the process is going to be like on the day we get together, and also more specific homework assignments. By that, I mean drafting stuff or anticipated drafting stuff. If we're going to have a creative business solution, for example, it might include a license agreement. Well, let's go ahead and get all those terms roughed in right now. It might include an injunction. Let's get those terms roughed in. It might include trying to eliminate some confusion in a trademark case. Well, what's that going to look like? Or we might have to put a former employee in the penalty box just because they've got some trade secrets that might be useful to our competitor. But we can start doing those beforehand so that we're not just caught flat-footed at the mediation in case the case does settle. Then much closer to the day we're going to get together, I'll ask you for confidential pre-mediation statements. Again, 5 pages. And in these, you can talk to me a lot more about settlement dynamics. You can talk to me about business interests. You can talk to me about a lot of those things that you didn't want to share with the other side in that first pre-mediation statement. And then we finally get to negotiation day. And it's great because we get to start almost immediately with negotiations. We can have longer, more relaxed, more informed, wiser discussions, I think. And in 2 or 3 hours, we can feel pretty good about whether the case is worthwhile to keep going towards settlement, or whether we need to postpone and do something else, or whether or not the case just needs to be tried. But we're usually finding that out fairly early on. And then if we settle it, we'll spend some time on drafting it, maybe an hour or so, and then we're done. And so it seems to be working out really well. I only have anecdotal evidence so far. I've done over 25 of these now in either complex or technology or IP cases using this method. And the feedback is generally pretty positive. What's most overwhelming is happy clients. The clients love this, and I get great feedback from them. And I think they're more involved. It's cheaper, it's easier, it's more relaxed. They're comfortable. They feel like they're a part of the process. I think it's been surprisingly good out there. We also have happy judges too. I think there's plenty of judges that as the cases started backing up because they couldn't try jury trials, and then we had to start prioritizing certain things, and the civil docket kept getting pushed down. One of the things I think other mediators and I have noticed, and again, this is just anecdotal, it seems like more cases are settling at mediation now. And it seems like they might be settling earlier. And assuming that's really happening, it's making judges happy. Now, I know we've just talked a lot about settlement, and I know how wimpy that is. And I know you're going to tell me, well, that's all well and good, Carl, but I'm a trial lawyer. Well, I appreciate the sentiment. And I think we're going to talk about some things now and show some demonstrations that'll help you see you can be every bit as an effective trial advocate as you were before, and maybe better, using the remote advocacy tools. There are some overarching themes here too for these tools. One, again, is you can do everything you did before. But secondly, you really are going to have to focus on the staging of this. It's going to take more preparation. I'm not going to kid you. You're going to work harder and prepare harder and more to be able to present these things online and be effective. And you're going to have to think about it in terms of the little TV screen. The other thing I've noticed is that if you had really good strengths of preparation and hard work and really getting on top of your case beforehand in the old days, those strengths get magnified in this new media. You look even better. Conversely, though, if you're just dialing it in and learning it with the jury, those weaknesses get magnified a lot too. Whatever you do, I think really learning the decision makers forum. I happen to use Zoom for mediations and arbitrations and courtmaster work. A lot of courts do too, other mediators do, but as you know, there are many platforms. But the point here is learn the decision makers platform. Learn it really well, and don't ever leave it if you can during the entire proceeding. So more on that later. As we try to set up these demonstrations, they're mainly based on my perspective as a decision maker and somebody that also consults with other decision makers. I tried to identify the consensus of problems and best practices that are emerging, and I've asked two real experts here in remote advocacy to assist me with dealing with these issues. Professor Tracy McCormick is the Director of Advocacy at the University of Texas Law School, and she's also the author of Remote Advocacy in a Nutshell, which is being published by West Publishing this month. Sherry Worth is president of the Exhibit Company and co-founder of exhibitsticker.com. She's also an adjunct professor in advocacy over at the University of Texas Law School. Tracy and Sherry.
Hi, Sherry and I want to share with you some ideas we have about how to make you embrace rather than resist this new foray into remote advocacy, and how to focus on your role and be your most persuasive self regardless of the forum. What we want to do is hit what we think are some of the less obvious things that people have thought about as we move to this new world. So you knew you were always the director of the proceeding, but now you have to take on the role of producer. Your witnesses, the judge, the jury could be anywhere. You have to do all the things that you always did, but you have to worry about the set and the sound and the lighting and camera angles, things that weren't part of your job as a lawyer before. So let's think about what the stage used to be. A courtroom has all sorts of implicit cues in it. The judge is high and everybody walking in knows where the judge is, and the witness has a specific place. Counsel have plaintiff's tables and defense tables. The jury is specifically set somewhere. You now live in a universe where none of those settings are there anymore. In a proceeding, it may just be you, the judge, and your opposing counsel, but it could also be something so much larger. Look at that screen. How do we know who the judge is? How do we know who the lawyer is or who the witness is? How do we know who's important and who's not? This is a very egalitarian approach to litigating, and it's going to travel with us throughout all of these forums. So let's think about what it is to prepare your witnesses now that you're the producer. Witness prep is going to be longer, it's going to be more intrusive, and it's going to take a lot more hand-holding. It's as if you showed up at somebody's house unannounced and asked to come in. You now have to think about how your witness is going to be seen and experienced. So all the work that you did getting yourself ready, thinking about camera angles and lighting, all has to be done with a witness. Witness can't be believed if they look like they're in the witness protection program. People will not listen very long to garbled audio. Backgrounds are now a whole new thing that you have to think about. And not just the obvious parts of background, but those things that signal wealth, signal disparities in economics. In the courtroom, witnesses walked in, they sat on a witness chair, and you didn't have to worry about all of that. Now you do. The screen, whether we like it or not, makes all of us need to appear like we are professional news anchors. In order to get that level of comfort, you're going to have to practice, practice, practice yourself and with your witness. Because at the end of the day, you're producing a courtroom experience, and you have to create all of that gravitas, even though you don't have any of the cues to support you to make that happen. So now let's talk about what happens behind the scenes, getting exhibits, exchanging them. We all know the best practices. You ought to exchange in advance. You ought to prepare for all of these things. We want to spend a few minutes, though, on the unanticipated document and on physical evidence. And so I'm going to let Sherry talk about that for a second.
Thanks, Tracy. One of the things that's really difficult in the Zoom world is dealing with physical exhibits. How do you show a physical thing that you hold in your hand? Well, there are some solutions now, and they're in the form of very small, very compact USB cameras that you just plug into your computer, and they act just like the document camera in the courtroom that you're used to using. You can even turn your iPhone into a document camera with the use of an app and a gooseneck stand that you can get from Amazon. And this basically turns your desktop into a document camera, just like one you would use, and you can use this for showing exhibits, you can use this for marking up documents, you can send this to your witness to use if they're more comfortable in that manner.
So what do you do with the unanticipated document? Well, just know that you need to be able to show it to the witness. You may need to show it to opposing counsel or your decision maker. You want to make sure the witness has sufficient time to adequately review the document. You want to make sure that you mark it, and you want to make sure at the end that it's part of the record. And you can do that through chat. You can do it through emails. You can do it through various mechanisms, but just make sure you've planned ahead even for that unanticipated document. Now you have to think about that you have all these things. How are you going to show and display them? So know your platform, learn your platform. You have to keep the attention focused where you want it. And just remember, every time you allow your audience to leave your platform, you don't know what you're doing. You don't know where they're going. It's like you allowed the judge to get up and leave the bench during your argument. So try to keep them focused and contained on your platform as much as you can. And Sherry's going to give you some tips to maximize that.
So now we'd like to give you some practical advice and tips on how to use Zoom or how to maximize your experience on the Zoom platform. We're choosing Zoom because the majority of the courts in the country are using Zoom. And also the mediators and arbitrators seem to be adopting Zoom too. It seems to be taking over. But if you're using some other platform like Teams, for example, you should have similar options available to you. So the first thing we want to show you is how to optimize your view in Zoom, and this is also important for your witness to show them how to do this as well, because we want you to be able to see the exhibits that are being shown very clearly on the screen. The normal mode in Zoom lets you have the panel at the top, very small, and the document large, but you can do a side-by-side mode, which gives you a little bit more flexibility. And I can come in here and move the slider bar, and I can arrange my screen now to kind of be a little more flexible to the way I need to see it. Maybe I don't need to see the panel and I need to see the document as big as possible, or maybe I need to see the panel and that's more important than my document. Perhaps I'm giving my own PowerPoint opening and I know what it looks like, but I want to make sure I can see what the judge looks like when they're watching the PowerPoint opening. So the side-by-side mode is a very convenient mode to know about. But more and more, it's becoming commonplace to have two monitors, and that is our recommended best practices, to have two monitors. They're very cheap now. You can get them at Goodwill for $20, big, nice widescreen monitors. They plug into your computer. They're not that complicated to set up, but it gives you so much more options to view your exhibits on one monitor and see your panel on the other. It's just so much more flexible, and we really recommend this. And some judges we've seen are using 2, 3, and even 4 monitors. But don't stop there. Think outside of that box. If you have a big screen TV that has an HDMI cable, it can be connected as a second monitor. And this became really important when we were doing some voir dire experimentations. When we hooked the voir dire panel up to a big screen television, suddenly it became very doable to do voir dire in that manner because you could clearly see everybody. If you're trying to see everybody on a tiny little desktop monitor, it's really not a good experience. So think about that. You can also get big screen TVs very cheaply these days. And there's another little trick that more and more, if you're going into a hearing, there'll be some court administrative people on the hearing, or you may have your own folks on the meeting as well, that they're not on video because it's not important for them to be on video, but their little name box shows up. So if you hover over any of those black boxes that just have a name, then you click on the 3 dots, there's the option to hide non-video participants. We recommend you do that because it just clears up the real estate and lets you see only those participants that you really need to focus on. Now, how do you actually share documents on your desktop? It's not that complicated, but it can confuse people. So we just want to give you a very quick tutorial. There's a green share button at the bottom of your screen, and that opens up a window. Now, if you have one screen, always in the top left, it's screen one. If you have two screens, the next screen is next to you. And then all these other things are windows that I have open. I have a web page open, I have a calendar open, I have PowerPoint open. So close all those things out, otherwise they show up here and it gets very confusing. So we're going to select our screen one, which will show us our entire desktop. And that is something to note because depending on what your desktop looks like, it could be very messy. So you want to make sure that's clean. And then you can browse out and just select the document that you want to open. And we'll go over the annotation a little bit more in another section, but just to show you, we can pop open a PDF and then go to town working with this PDF. And when we need to change our documents, we can browse out to the next document and pull that document up as well. But there is a neat tool to know about, and we want to show that to you in the next little video. One problem with sharing your desktop, as I was showing you, is everybody sees everything on your desktop, and they also see you going to find the files you're trying to look for. So if, particularly in impeachment, if you are trying to quickly find a document and you have to go digging around on your computer, you don't want everybody seeing you do that. So there is a pause button, and this is one of our favorite tips. If you are on a document and then you click on the pause button, it freezes that document for everybody else. Now they're not seeing this part where I'm going out and looking for documents until I pull up what I want next and I click the resume share. So I can go out, browse around if I have that pause button on and feel confident that I'm not showing anybody anything that I shouldn't be. There is another way to share documents, which is sort of an expert way, but it is the best way in our opinion, and it's in the Advanced tab under the Screen Share, and you share a portion of the screen. So when you do that, it'll bring up a green bounding box, and you pull the green sides, the little rectangle around whatever part of the screen you want to share. So in this instance, I'm going to window around this actual document here, and then you can see the audience is not seeing my toolbars. They're not seeing me going up and clicking on my annotation tools. All they're getting is this clean experience of just the document. And that becomes important in the next step where we go in and annotate and we save, we exhibit sticker, and we exchange our document. So when you pull up the document, let's say you can see our green bounding box, we're sharing a portion of a screen. There's an annotation function in Zoom that's quite user-friendly. It takes a little practice though. Just go ahead and play around with all the tool sets in here. You can draw lines, you can add arrows, you can certainly do highlight boxes. I really like the spotlight tool, which is this little red laser. And when you're ready to save it, make sure you select a PDF, click Save, and then you have now captured that document with all the annotations on it. So your witness could be doing that, and then you could save it out so that we want to distribute this to the court. So now you see this is the PDF that I just saved. I'm going to go ahead and name this Exhibit 1 for this example, and then we'll show you how to exhibit sticker it in the next little video. So if you need to exhibit sticker on the fly, if you go to exhibitsticker.com and download their free exhibit sticker, get that loaded before you need it and practice with it. But when you do get it loaded, all you have to do is click on the stamps tool, pull down the exhibit sticker stamp, select it, and then this is our exhibit 1, so I'm going to click there where I want it, type in exhibit 1, select OK, and then you can see we now have our digital exhibit digitally exhibit stickered, and we can now get ready to exchange it. To exchange on the fly, Zoom allows you, if you've been given permission, to upload documents through the chat feature. It's a very simple way to go ahead and exchange exhibits as you're moving through your hearing or deposition and so forth. Everyone can download this file once it's been loaded into chat. Again, that has to be, you have to be given permission by the host to be able to do that, but you can request permission to be able to exchange through chat, and it's a very handy way. And as Tracy mentioned earlier, you really don't want your audience to be leaving the platform and have to find their way back to you. One of the last things I want to show you quickly here is the whiteboard feature. So if you go in the Basics tab, there's a whiteboard that you can select, and it's like you would think it's a blank piece of paper, it's a blank canvas, and you can use the same annotation tools that I was showing you earlier to go ahead and use with an expert. And I know Tracy's pretty adamant about being able to do all the things that we could do before, and this is one of those functions that not many people, I think, are aware of. Tracy, did you want to say something about this?
Well, just if you're used to using that in a live proceeding, then use it now. So if you like putting up the expert's qualifications or testimony and you want to put that in a text box and then check off that you've done things, if you want to say that here are the following things that they didn't do, and you want to use that and use X's through it, you can. What we want you to know is that whatever you could do in a courtroom, you can do remotely. So don't compromise your advocacy or unnecessarily limit it because you didn't realize all of these features were out there. So once you have all of this stuff in hand, you need to keep your attention focused where you want it. So think about little things like naming yourself for every proceeding. Remember, the judge, the arbitrator doesn't have counsel tables anymore. So just doing simple things like that on a large screen with multi-parties can be very, very helpful. We'll quickly go through just some slides to show you how you might identify the parties. Perhaps you've got a TRO where you have lots of parties and the judge may not have a file or pleadings. So you want to make it as easy as possible to follow. Make sure that we can find the information from documents. You know what's in those documents, but your decision maker doesn't know what's in those documents. I have this dream that, poor judges and arbitrators all around the country get a daily delivery of the big black binder. And it's just filled with the data, it's filled with all the backup, and then they're going to have U-Hauls cart this off when we eventually go back live. Think about how helpful a history of the case would be, or a timeline will be to any decision maker. Suppose you've got magistrates that were handling parts of proceedings and now it's to the judge. They may not have that file. You may have had Markman hearings. You may have had other proceedings going on. And so the easier you can make it for your decision maker to keep up with your message, the better. Remember, you've got to account for audio lags, visual lags. You may have somebody that drops off for 10 or 15 seconds. So you want to use all these demonstratives to make sure that they can easily keep up with your message and to make sure that you're being redundant with your messaging, not repetitive. And then finally, here's a couple of different ways to use chat. You could be putting all the acronyms in your case in chat. You could pull up the witness's name and let us know, give us a little description of who this witness is going to be and what exhibits we're going to be using with that witness. The easier you make it for your decision maker to follow your messaging, the better off you're going to be. And then finally, let's address those elephants in the room. All of the things we've been worried about, what? And what's the first one? They can cheat. Well, lawyers have always sadly been able to cheat. But think about how hard it really is to do in this new forum. It's going to be real obvious if I'm sitting down getting text messages from my opposing counsel. It's going to be real obvious if I'm looking away because somebody's sending me messages and in the room with me. You're going to be able to deal with cheating. You could have a clean sweep of the room before you began to make sure that nobody's in the room with the witness. You could have them use their phone to show you that after every break. You could monitor the chats and have the court only review them if you suspect that there was something going on in private chats that you didn't see. You could even go so far as to get telephone logs to see if there are texts between counsel and their witness during the time that you were doing testimony. The courts and arbitrators, they are ready for this. They've always been able to deal with cheating, and they're going to be able to deal with it here. What about the smoking gun, right? I can't surprise them. Now think about it. When was the last time that you were so surprised by something that your opponent did during the case that it actually changed the course of the case? Surprises don't happen very often. We gave you a few tips on how to handle the unanticipated document, the unanticipated information. Just remember that if you do have that surprise, put your producer hat on and make sure that you capture it. Make sure that you've got a camera angle that's focused on the witness's blank stare as opposed to everything up on a big shared screen and 5 different people and we can't tell who the witness was. And then finally, the big one is credibility. What the science tells us is that we overestimated what we can do when we physically see people, and we underestimate what we can do in a remote proceeding. The voice and eyes are always the best cues, and you get that and you get it better than you ever did in a remote proceeding. So just remember too, to compare this to reality. The current reality is that you either have a choice of doing it this way remotely, or you're trying to gauge the credibility of a witness behind plexiglass with a mask on and with somebody 20 or 30 feet away. What you could do in the real world in an in-person proceeding, you can do in a remote proceeding. We hope these couple of tips help you feel comfortable so that you can embrace being a remote advocate as opposed to resisting it.
So thank you very much, Tracy and Sherry. Let's kind of see where we are and when we're going back to the way we used to do this. Well, in my opinion, we're not going back. We're not going to return to the old days. And if you think it's going back to normal in the first part of this next year, I just have to disagree with that. What are some of the reasons why I believe that, based on my experience so far with the remote advocacy? Well, one, the clients are just not going to allow it. They love this. Their eyes have been opened. It's easier for them. They can integrate it into their lives so much easier. It's much cheaper for them. And I just don't think they will be hiring law firms that aren't real good at remote advocacy. Second is, we've got a bunch of reformed judges out there now. A lot of judges started out very resistant to this, and through necessity and help of a lot of resources, they've been converted. And I have to tell you, reformed judges are like reformed smokers. They're not going to let us go back. Finally, I think we've really exposed and brought into sharp focus the access to justice problems that can now be solved. These are problems that have plagued us for 50 years, and we've got a chance as professionals to really change the justice system. I know that we all focus on zealously representing our clients as advocates, but we also are now being reminded we have obligations to the justice system and to society at large. And we are the professionals that are supposed to know how to help people best get their disputes resolved. I think as we move forward, you're going to see much, much, much more focus on what is being called digital justice. We'll be incorporating more things online and remotely. Now, there'll also be a lot of hybrid systems too, using the best of both worlds, and occasionally only the in-person start to finish will do. And that will be, I think that's what the future holds for us. We don't really have to speculate quite as much anymore, and I think we'll get more research in the future on this, but just recently, Professor Elizabeth Thornburg at SMU School of Law and some of her law students watched a bunch of trials, and they have just recently published their data, both the quantitative and the qualitative results in a paper, and it's in the resources. I encourage you to look at it, and I think there'll be more of this where we don't have to speculate anymore about how everybody's reacting to this. Finally, I have to say, I've tried to include as many resources as I could, and there will be a paper on it. as part of the materials here. And if I've missed one of your favorites, I apologize. Send it to me and I'll add it to it. And if I've offended somebody by including something, tell me. I will say this, before you start working your way through these resources, though, which some of which can be pretty heavy or pretty detailed, I would really encourage you to watch one of the other resources that's listed in there. It's authored by a fellow named John Acuff, and it's the top 10 worst Zoom habits. And although they're funny and he does a great job with it, they're also spot on true. So have some fun, watch that, and then start studying. Thanks for letting us present to you. And now we're turning to questions.